mentioned, I'm Meghan Mccaig. I'm an employment and labor partner in our Dallas office. I have together with me Andrea James, who is a senior associate in our Houston office who does employment and labor work as well. We're very excited to present this topic to you today, talk to you about the best practices for investigating employee misconduct, and also some potential pitfalls and what to avoid. So we'll go ahead and get started.
Thanks, Meghan.
Yeah, Andrea is going to kick us off.
All right, so we're going to start off today by just thinking about the importance of conducting investigation. So why do we investigate? Employers conduct internal investigations primarily for business reasons, to make sure they're in compliance with different laws or policies, to ensure consistency in disciplinary actions. Investigations obviously require you to track, how you discipline employees. And so that allows for employers to create consistent practices. Defending against whistleblower and retaliation claims, also to help defend against harassment claims. In some cases, employers could waive an important defense if they fail to properly investigate, say, a harassment allegation. And so that just underscores the importance of conducting the investigation, but also to identify and prevent workplace misconduct, right? Sometimes you discover things in an investigation that may not have been the primary purpose of the investigation. So sometimes they can also be used as preventative. And finally, investigations demonstrate that the employer takes allegations of misconduct very seriously. Regardless of whatever the legal obligations are, usually when employers are promptly responding to employees' concerns, that's often the best way to avoid litigation. And employees who feel like their employers have heard and addressed their complaints are typically less likely to seek redress in court. And these are just a list of some of the things that prompt an investigation. It could be anything from an employee complaint about misconduct to a potential media report. So something that made it to the media, say, prior to the employer actually learning about it, say, from one of its own employees. So it truly does vary, but given the variety, it's important for employers to just make sure that they're, thinking about all the different reasons why they may need to investigate, and not simply only to be prompted from an employee complaint.
Okay, so talking about some of the applicable laws that will kind of trigger an investigation or are the reasons why an employer would investigate. I mean, I think most people in the field understand and know about Title VII, which, protects against discrimination on the basis of race, national origin, religion, color, and gender. You obviously also have the Age Discrimination and Employment Act and the Americans with Disabilities Act. So typically, those are the most common things that employees will bring up to an employer as they feel like they've been discriminated against or harassed on the basis of one of these protected categories, and that will prompt an investigation. So those are pretty standard. I think employers are fairly used to investigating those subjects. Some other things that will or should prompt an investigation is if someone complains about having requested FMLA leave, under the Family Medical Leave Act, and either not having been given it or being retaliated against for having taken FMLA leave. So a boss says, when an employee returns, I'm assigning you over to this less favorable location because you took FMLA leave. I mean, typically it's not going to be that obvious, but it'll be the way the employee feels as a, result of having had some kind of action taken after FMLA leave is taken. IRCA it relates to immigration. So these are, if you get a complaint about someone not being authorized to work, that's typically what will prompt an investigation there, that those should be taken seriously and looked into, because that can yield potential criminal liability for the organization. And another thing that IRCA requires is collecting the proper documentation under the statute when employees are hired. So, and there's a records retention requirement for keeping people's, copies of people's either passports or social security cards and other forms of identification. So a complaint like that could prompt an investigation. Worse, you could have an inquiry from, DOJ or USCIS relating to employees who may or may not be unauthorized to work, and that'll prompt an investigation. The Fair Labor Standards Act is one that is coming up obviously more and more, which is, the obligation to pay employees a minimum wage and to pay them overtime for those employees who are non-exempt. So if you get a complaint related to an employee not being paid minimum wage or not being paid required overtime, those are things to take seriously, because plaintiffs' lawyers these days have been really kind of keeping an eye out for those and filing collective actions that are, often difficult to defend. So if you get a complaint and you can kind of mitigate that and take care of the employee's concern, assuming it is a valid concern on the front end, that's the best way to go for sure. OSHA, the Occupational Safety and Health Act, that is, OSHA has numerous regulations related to employee safety. And so if you get a complaint about an employee feeling like a workplace is unsafe physically, so, an oil field worker who complains about a safety violation, or someone who works in a factory, those are things that you're going to want to investigate. Sarbanes-Oxley is really more whistleblower and retaliation. So you want to prevent taking any kind of adverse action against someone who reports a potential violation of securities laws or accounting requirements. Just take a look into that and make sure that there isn't any adverse action taken against an employee who comes forward as a whistleblower. And then obviously there are any number of state laws, depending on where the company operates, that govern very similar subject matters. Okay, so litigation risks and how to mitigate them. So these are the major risks that come out of employees coming forward with complaints. So first and foremost is the risk of retaliation. So, that someone is going to then take an adverse action against that employee for having complained about something. And so, we'll talk about this kind of throughout the presentation, but it's important to make clear to everyone involved in the investigation that no adverse action is to come against an employee who makes a good faith claim or raises a good faith complaint. In very rare instances, you have someone who raises something in bad faith that is clearly false and it's objectively proven to be false, and that's a different story. But if they're raising it in good faith, you are going to want to make sure that even if it's ultimately not found to be true, that employee is not retaliated against. Privacy. So if you are, oftentimes people find out, this person who's accused, we want to run a background check, or we want to run a credit check or something like that, or against the, about the complaining employee. Those are things that you're going to want to consult probably with an outside attorney before you do them, because it can be a violation of the Fair Credit Reporting Act if it's not done correctly. Requesting medical information, there are parameters around that under the Americans with Disabilities Act. So just be careful. There are instances in which it's very appropriate, but there are also instances in which it would not be allowed. And so you want to avoid making the investigation worse by running afoul of the ADA, by requesting, or the Family Medical Leave Act, by requesting information that the employer is not entitled to. Searching employees' belongings. I mean, there are places where that can be appropriate. There are places where that wouldn't be appropriate. And so it's just keeping that in mind. I mean, if you're looking through employer property, for example, you know, an employee's desk where somebody wouldn't have an expectation of privacy, that may be okay. But if you're looking through somebody's handbag, that's, you know, obviously has their personal belongings in it. You want to make sure that you have reasonable cause to do that. The Wiretap Act, this is not generally a concern because typically employers are going to be looking through electronic records that are on their own systems, and that is permitted. But if you're looking through electronic records or trying to access something that is not on the employer's system, there are potential risks associated with that. So you're going to want to consult with a lawyer before that happens. The Polygraph Protection Act, I mean, I doubt anyone here would be polygraphing their employee, but there are obviously limitations around that. So if that's something that the company wanted to do, I would advise consulting a lawyer before you go ahead and do that. Discoverability. So keep in mind that, you know, this is oftentimes a factual investigation unless you have outside counsel involved, or unless there's some reason that litigation is imminent or has already been initiated. It's not going to be protected by the privilege. So you want to be careful. I'm not saying don't put things in writing. Obviously, you know, that's unavoidable, and you will want to prepare a report, but just be careful about what it is because it's going to be discoverable. The National Labor Relations Act, this is typically, you know, you can tell that the NLRB has said that it's permissible to tell employees during an active investigation to keep the investigation confidential, but you want to avoid telling employees to never talk about the investigation even after it's concluded, because that can violate the NLRA. Defamation, you know, you just want to be careful telling people who don't have a need to know about allegations, because assuming they're, you know, they end up being untrue, the employee who's the target of the investigation may end up bringing a defamation claim. And then there are some can be contractual risks or restrictions if you have union employees, and there's also for unionized employees, Weingarten rights, where you need to be sure that if an employee asks to have a representative with them in an interview that's reasonably likely to lead to discipline, that you allow them to do that.
So next we'll talk a little bit about some investigation goals. So first, you want to determine whether or not a problem exists. And so thinking back to what Meghan mentioned about how, you know, sometimes people bring complaints in bad faith. And so making a decision about, you know, whether this is the type of conduct that the employer is actually going to investigate. Once the employer decides to conduct an investigation, then the employer typically needs to move forward thoughtfully and methodically, but also expeditiously. And we'll talk a little bit about timing later. But one of the first steps is to just agree on the particular goals for the investigation with whomever the relevant group of individuals involved in the investigation will be. And then once the relevant goals are determined, then the employer can decide kind of an investigation plan for meeting those goals, keeping in mind that, you know, protecting the company is of importance, you know, meaning that, again, you want to make sure that your investigation is thorough and that you are doing all the things that are necessary so that you don't open yourself up to liability in the future. Demonstrating fairness by the company, which will improve morale. As was mentioned earlier, employees generally, like to see that the company takes allegations seriously. And so when employers do investigate, employees typically are appreciative and, have confidence in their kind of human resource system. And then also encourage employees to report problems to management and to use the company's internal dispute resolution procedures. I'm sure some of you have encountered employees who have, talked about their distrust in potentially the human resource groups or, distrust with certain individuals. And so, this again just underscores the importance of having clear investigation goals and a clear process, one that employees can kind of believe and trust in so that they continue to report valid complaints and allegations as necessary. Who should conduct the investigation? So the key kind of preliminary considerations are whether the investigation should be conducted internally or externally, and whether or not it should be conducted by an attorney or a non-attorney. And that will depend on kind of the nature, severity, and scope of the matters that are being investigated. And so once you've had a chance to kind of weigh those factors, then you can make an informed decision about kind of who should be conducting the investigation and whether it's done internally or externally. When deciding whether an investigation should be conducted internally or externally, sometimes employers will take into consideration costs. Conducting an investigation internally will usually cost less than, finding some third party or outside party to help. However, conducting an investigation with someone externally may help reduce the likelihood of employees thinking that there's some kind of bias, particularly if there, are concerns about, the people, let's say, in the human resource department. Perhaps they may have some involvement in what's being alleged. And so it might be best to bring, an outside organization or counsel in to help with the investigation. Similarly, whether an investigation should be conducted by an attorney versus non-attorney, cost may be something that you take into consideration. But also, depending on the nature of the investigation, if this is something that you think is more likely to become litigious, then it may make sense to get an attorney involved earlier in the process, so that you can begin to kind of weigh and evaluate some of the claims in thinking about how to move forward with the investigation. And then finally, and I kind of touched on this a moment ago, but choosing an investigator who is impartial, right? So that is key for an investigation. You certainly don't want someone who is biased towards one party or the other, because that will certainly be something that is raised if, depending on the outcome of the investigation by an individual who may not be pleased with the outcome. And so you just want to make sure that, it's as clean as potential as possible to avoid kind of any accusations that there was some type of partiality during the investigation. And then finally, preparing for the investigation. So preparing for the investigation requires that you begin the investigation immediately. In rare circumstances, would you ever want to kind of wait to conduct the investigation? Perhaps if maybe there's an allegation of theft and you need to surveil, the employee for some reason or another, maybe you'd want to kind of provide yourself a little bit more time. But that aside, beginning the investigation promptly is key, so that the parties involved don't feel like you aren't taking the allegations seriously, but also so that you can hopefully reach a quick resolution to whatever the issues and claims are. It's very important to preserve documents. Oftentimes there'll be multiple parties involved in whatever the allegations or claims are. And so to the extent that it's appropriate, you'll want to, inform the participants to kind of preserve whatever documents or information they have, not to start deleting things, whether it's intentionally or sometimes inadvertently. A lot of email systems these days kind of have automatic delete features. So making sure that there's a clear understanding that documents need to be preserved in order to, continue with the investigation or to start the investigation. Reviewing documents, right? So to the extent that there are documents to review, reviewing those in advance of meeting with different witnesses or individuals who may have information related to the investigation will be important, because a lot of times the information in those documents might be the information that you will want to question the witnesses about. And so making sure that you've got that information readily available to you, and hopefully kind of the universe of those documents. More than likely, you'll discover more as you begin the investigation, but certainly having a basis to begin with is super important. Preparing witness outlines. So key questions are who, what, when, where, and why, right? So thinking about the individuals that you are going to want to question in the investigation, and then coming up with, as detailed outlines as possible, keeping these kind of 5 W's in mind, right? Obviously, as you, question your witnesses, you're going to get responses that are going to lead to questions that aren't necessarily covered in your outline. So don't feel, compelled to stick to your outline specifically, but having kind of a basis to start, and also kind of a guidepost, so that if and when things do get derailed, you have somewhere to go back to, and know kind of the important points that you want to make sure that you cover, so that you don't have to, keep calling people back to ask more questions down the road. Certainly, if that's necessary, you can. But one way to help prevent that is to just kind of have an outline prepared in the beginning that has a list of kind of everything that you want to cover. Prepare a chronology of events. This is another super helpful tool that will, help guide you and the other people involved in the investigation who are helping you conduct the investigation on kind of what happened when, right? So to the extent that you're able to prepare that chronology in advance of meeting with the witnesses, it's a really helpful tool. And then as you meet with individuals, you can start to fill that chronology in. And to the extent your witnesses are sharing information that seems kind of outside of the chronology, you can, start to question them about it, and hopefully uncover, more information that you otherwise may not have been privy to. And then finally, determine whether it is necessary to suspend or transfer the subject of the investigation, grant an accommodation to the complainant, or modify reporting relationships during the pendency of the investigation. So these are all things that employers should be thinking about and considering, just depending, again, kind of on the scope and nature of the investigation. So for the purposes of suspension or transferring, a lot of times in our harassment complaints or allegations of harassment, you'll see employers exercise the option to potentially suspend or transfer an employee, particularly the accused, during the time of the investigation. But again, you have to kind of make that business judgment call depending kind of on the severity of the allegations and kind of what you're able to gather initially. And, you know, sometimes it may be also an available option to transfer the alleged victim of the complaint in order to potentially, you know, avoid any further harm that they are accusing the individual of doing. Potentially granting accommodations to the complainant. And so again, that could look like a transfer. That could look like potentially taking some days off during the investigation, or just other ways to accommodate whatever the needs are of whomever the individual that complained is. And then finally, modifying reporting relationships during the pendency of the investigation. This is similar to kind of the suspension or transfer. If, you know, the individual who is the accused in the investigation is in the reporting line of the person who has raised the complaint, you know, depending again on the severity, it may make sense to change that structural relationship. And so whether that's moving the person who raised the complaint to report to someone different for the time being is certainly an option that employers should consider, just to kind of help, again, make sure that the investigation is done kind of as cleanly and smoothly as possible.
Okay, so hopefully people can hear me better now, and I see there's a question. Hang on one second. Okay, the question is, do we recommend legal assisting with the draft of the outline if they are not participating in the investigation? It can be beneficial. So the issues are, do you want your kind of outline to be protected by the attorney-client privilege or not? The other issue when deciding whether to involve legal is if you are using an outside lawyer. Sometimes the outside lawyer will then be disqualified from representing the company if there's any further litigation, because they are involved in the kind of underlying facts. And so that's a question as to whether you want to sort of, I won't say poison the well, but use the particular outside counsel if you're going to want that lawyer or law firm to represent the company in litigation. But I would recommend, if you have in-house counsel, involving them as much as possible, particularly if you think that the complaint is ultimately going to result in litigation, because you're shielding those communications from the attorney or from the, complainant. They're going to be covered by the attorney-client privilege. And then going back one slide to the, potentially granting accommodations to the complainant. So if you are transferring someone, or, with respect to the complainant, you don't want to take anything that could be viewed as an adverse action against that individual. So if they request a transfer, that's certainly something that and they would agree to it, that's certainly something that I would offer to them. If they don't request a transfer, and you're moving them to a different location, you're leaving the accused in the current location, that could ultimately be something that could be used against the company. So I would advise against that. And if you're going to move anyone, move the accused and not the person who complained. So it's really, you're more than free, obviously, to give something that the accused or the complainant requests to them if it's something the company is willing to do. But I wouldn't do anything to the complainant with respect to terms and conditions of their employment unless they specifically ask for it or agree to it, ideally in writing. Okay, so going to the next slide, talking about interviewing the complainant. So that is typically the person that you're going to want to talk to first. And some of these slides will be a little bit repetitive because some of the interview processes are the same with respect to, each person that you're going to interview, but you always want to explain the process. You also, with respect to the complainant, want to be sure to explain to them that if there is misconduct and it is confirmed in the course of the investigation, that misconduct will not be tolerated by the company, that there will be action taken as appropriate by the company. You also want to assure that person that they will not be retaliated against for having come forward in good faith and raising a complaint. So confidentiality, we talked about it earlier. You can ask people not to discuss the investigation during its course, but make clear, or at least don't tell them they have to keep this confidential for all time, because that can be an NLRA violation. Just ask them, while we're investigating, we'd ask that you keep this investigation confidential, so as, you're essentially trying to make sure that that person is not going to interfere with what other people are going to say during the course of the investigation itself. This is pretty obvious, but you want to make sure that the person investigating is, as Andrea said, is impartial, so they're not going to be taking sides or expressing opinions. Also, make sure that you have someone who can be serious, because jokes, while sometimes are appropriate to lighten the mood and during the course of an investigation, are not appropriate. One of the first things that you're going to want to ask is with whom the complainant has discussed the allegations, because you're going to want to make sure, to talk to those people probably during the course of the investigation to see what the complainant has told them, but also to explain to those people, to the extent they told their boss or someone else, that they need to not retaliate against the employee for having raised a complaint. And also ask for other witnesses. So, if someone is complaining about a safety violation, say, well, who else, would have witnessed this issue? And, is there anyone else who would be able to talk about this particular issue, so that then you can make sure to go and talk to those people as well. Okay, so continuing, you want to ask for physical evidence and documents. I mean, physical evidence may not be the case if there's, if the person has made a recording, which, sometimes happens, you want to make sure that you listen to that. But typically it'll be, chats, texts, emails. So any kind of documentation the person has. Ask if the complainant has any other complaints about the person against whom they're making the allegations, so that you know the universe of what it is you're dealing with. Ask if that person, the complainant, has made prior complaints about other individuals. You want to determine if the complainant believes that their job, the terms and conditions of their employment, have been affected in any way. This can be helpful later if there is ultimately litigation, because often it's, well, I feel like this, or I think that, but it's not a concrete effect on their job. it may still ultimately be the company's judgment if the complaint is confirmed that that conduct is inappropriate and needs to be stopped, but it may not constitute an adverse action under the law, which would be helpful to know at the complaint stage. It's just something you want to make sure you know. You also want to make sure to tell the complainant to immediately report any further problems that they're having so that they, you are sure that you are understanding the universe of what you're dealing with. And if they don't complain about it, again, there's some further issue, they never raise it, that you've told them, I want to know about any further issues so you're not dealing with something. It's a way to deal with that later if they come back and say, well, I had all these issues, but I never raised them with the company. You always want to thank them, complainant, everyone, for their cooperation with the investigation process. Tell them, especially with the complainant, that there may be further interviews necessary after you've spoken to the accused and the other witnesses if you have follow-up questions. You do want to take notes. You do want to potentially ask the complainant to sign an interview summary if you feel like under the circumstances that's appropriate. And you also want to document if there's any refusal to cooperate. So if there are any questions that you ask, if they refuse to answer, or if they just refuse to talk to you at the outset, which would be odd, but I mean, it's not unheard of, you want to make sure to document that. Okay, I see a question in the Q&A. Okay, regarding recordings taken by a party or witness, if you are in a two-party consent state and a party or witness informs you that they surreptitiously made a recording, should you still listen to it or receive it knowing that they did not have consent? I mean, I probably, given that it's been done, I don't know that there is necessarily, it's the person who recorded it who's going to have been in the wrong. And if it's evidence, in the investigation, I would probably be inclined to, I guess it would depend on the circumstances, but if it was something that the complainant was bringing forward as, this recording substantiates the complaint that I've made, I'd be inclined probably to listen to it. I'm not sure, it may depend on the statute in this particular state, but in most states, it's unlawful for one party to record, in a two-party consent state, that is. It's unlawful to record another person without telling them and getting their consent, but I don't know that it's unlawful to listen to a surreptitiously recorded conversation. So if you think that it is evidence, I'd be inclined to listen to it rather than to say, particularly to a complainant, I can't consider that. I'd be inclined to listen to it then. I certainly would not encourage someone in a two-party consent state to surreptitiously record someone. But, if you are presented with something that already has been done, you might tell the person that's not permitted in this state. But, if it's evidence, I'd be inclined to listen to it. Okay. Next slide. All right, so the next person you may want to talk to, you may do this right after talking to the complainant, or you may interview other people in the interim, the other witnesses, and then go to the accused. But when you are interviewing the accused, you want to tell the person that you've received a complaint. You definitely want to have an innocent until proven guilty attitude. So I would certainly, there are people who come forward with complaints all the time that end up not being capable of substantiation. So that's certainly the attitude that I think it's appropriate to take when you're talking to the person. A lot of these are, the same that are true with respect to all interviews. You want to be impartial, remain serious. with respect to the accused, you want to stress that there are no preconceived notions, and that, the company is going to be fair and open-minded and consider their perspective. You may want to have them discuss or sign a confidentiality statement, again, limited to the course of the investigation and not thereafter. You also want to tell the accused not to, particularly if it's someone in a higher position than the complainant in that chain of reporting, that they must not take retaliatory action against the person who made the complaint. It may, under certain circumstances, be appropriate not even to tell the person who made the complaint. There may be instances in which you have to do that, or in which it may be obvious who it was that made the complaint. I think when speaking to anyone other than the complainant, disclose only as much information about the course of the investigation and the complaint as is absolutely necessary to do the job. So, don't talk to someone about the details of a complaint that are not necessary for, that for resolving the complaint at issue. Okay, next slide. Okay, yes, you do want to ask them for sure if they knew about the complaint before the interview. It's just something that you're going to want to know, because that also can help you know how broadly the complainant has been telling people about their issue. And also if the person knew of the complaint before the interview, you want to make sure to figure out, has any kind of action that could be perceived as retaliatory been taken after the accused found out about the complaint, so that you can make sure and address that as well. You need to talk to the person about discussions that they've had with the person who made the complaint and third parties about the particular issue. Again, where appropriate, you can provide a copy of the complaint, that in many instances may not be appropriate. And you certainly don't want to disclose more than you have to. You want to go through all of the allegations with the accused. You want to make sure that you cover, person A, complained about this, and talk about that. And then, any other complaints, you want to make sure you give this person the opportunity to respond to each and every allegation that's been made. Again, where possible, don't reveal the source of the information. So you may have had intervening interviews with other witnesses, and, if at all possible, don't reveal who said what about the source of the complaint or any other issue. You do, as Andrea said, want to use open-ended questions and ask things like who, what, where, when, why, and how, and then follow up as needed. Okay. Yeah, you do. So avoiding loaded terms is fairly obvious. You want to ask if the people are friends outside of work or have some pre-existing relationship, not only between the complainant and the accused, but also with other third-party witnesses. So for example, say you have a third-party witness who you've talked to who's favorable to the accused, but it ends up being that person's brother-in-law. You'd probably want to know that during the course of your investigation. Go over policies and documents. If the person denies what you're asking about, you can ask, okay, why would they have made this complaint? Is there any other reason they would say X about you? Because potentially there is an alternative explanation. If that person says, well, so-and-so made it up, ask why, because, they may not have a good explanation for that, or they may have a very good explanation for that, and you'd want to know. If you are aware of prior complaints by the person who raised the complaint. You ask, whether the person is aware of that, or if there have been prior complaints about that person by other people, you would want to ask about those as well. Again, thank the person for their cooperation, explain, you may emphasize again the non-retaliation aspect of it. You may ask the person to review and sign an interview statement, depending on whether that's something that you want for your files, and document any refusal to cooperate. Okay, other witnesses. You want to talk to people who are identified as having knowledge of relevant information. If you're not choosing not to talk to somebody, you probably want to document why. So if the, complainant identifies person X as integral to their complaint, and there's some reason why you can't or don't want to talk to person X, you might want to document that. Similar things, these people are relatively easy to deal with because they don't typically have any reason to be dishonest. They just want to, tell you what happened. Again, avoid revealing information about the complainant or the accused unless it's necessary, and talk about confidentiality during the course of the investigation. Some things you want to cover: prior discussions that they've had with both the complainant and the accused, if they were aware of the complaint before or other problems that are similar. Ask if they know why the complainant would want to make that such a complaint, or why, if any of the other witnesses might have potential motives, again, without revealing too much information, or why somebody would have provided inaccurate information. And finally, you may want to have them sign an interview statement, and if they refuse to talk to you, you'll want to document that as well. And I think at this time, Ryan might put up the poll for CLE.
Thank you so much. If you are seeking CLE credit for today's presentation, please answer the poll question that will now appear on your screen. Did the poll launch for everyone? Let me try and relaunch it.
I saw it and then it disappeared. There it is.
Ready? There we go. Thank you so much, and I apologize for the interruption. Back to you.
Thanks, Ryan. So next, we're just going to talk about a few do's and don'ts. So this kind of summarizes and covers a lot of what both Meghan and I have talked about. Do explain the process. So when you're meeting with the different individuals as part of the investigation, explain at the outset the purpose of the investigation or the purpose of the process. So, why they're here and kind of what they can expect from the investigation. Be prompt and thorough. We talked about this earlier. You don't want an investigation to linger on. That obviously is going to create a lot of buzz around the office. And so, resolving or trying to resolve and get finished with the investigation as quickly as possible, but also thoroughly, is very important. Explain confidentiality and non-retaliation. Meghan mentioned earlier about the NLRA and some of the implications there with confidentiality, but that it is okay to remind employees that during the time that the investigation is pending, not to kind of speak and share about what was discussed. But also it's important to remind employees that their participation in the investigation won't result in any type of retaliation. A lot of times you have employees who will express that concern. And so, making sure that they are reminded of that before participating is always important, because even if they have not expressed that concern, that may be something that is on their mind. And then finally, just to be courteous, professional, and fair. We see that fair and impartial kind of piece creeping in again. Because again, to the extent that their, employees feel like the investigation wasn't conducted in a fair manner, that could raise just a host of other kind of concerns or questions. And of course, being courteous and professional will also kind of help alleviate some concerns as it may relate to fairness or bias. Don'ts would be don't delay. Again, we want a thorough and prompt investigation. Delaying may kind of bring down the morale and make employees feel like you aren't taking the investigation seriously. Don't overpromise. So certainly not telling employees that, there's going to be a certain outcome to the investigation or that something specific is going to happen in this instance. Really, the only thing you can do is conduct the investigation. And depending on what you discover, that's the point that you start making decisions about kind of what's going to happen and what's not going to happen. And so making sure you don't overpromise things early on so that employees don't kind of get their hopes up as the investigation continues. Don't disclose information. And so, Meghan touched on this a bit, but you really want to gather information, right? The purpose of this is to gather, not disclose. And so you only want to discuss kind of what's necessary with the individuals that you are interviewing, not kind of answering substantive questions about the investigation. So that kind of goes into the next one. You don't want to answer questions that kind of reveal the substance of the investigation. This is a time for you as the interviewer or as the employer to be gathering information. So disclosing kind of, who you spoke with or what other individuals said, shouldn't really be necessary to kind of conduct a thorough investigation. Again, explaining the process early on will hopefully help answer a lot of the questions that employees may have, and explaining to them early on about the things that you won't disclose may help alleviate them from kind of inquiring about things that you don't intend to disclose during the investigation. Don't perform background checks without consulting with an attorney. Again, that's something that you want to make sure you involve counsel with, just because there are, a lot of state-specific laws that might, implicate an employer if these checks aren't conducted properly and in accordance with the law. Don't ask for medical records or examination without consulting an attorney. Again, there are, specific state and federal laws around gathering this type of information. And so making sure that you are kind of in adherence to those, not stepping outside the bounds of those is going to be important. So, if it is something that is necessary and that will come up during the course of the investigation, then just consult with an attorney in advance so that you can make sure you're going about the questioning in the appropriate way. Don't surreptitiously record. We talked about this a little bit earlier, but yeah, you don't, unless you've kind of shared with the other party that you intend to record the investigation, it's not recommended that you do it kind of secretly, particularly if you are in a two-party consent state. But even if you are not, that will just kind of undermine the credibility of the investigation. Some of the fairness and bias considerations we've discussed may come into question if you are recording without sharing that with the individuals involved. And finally, don't search employees' personal belongings. Again, this is something we touched a little bit on earlier. Surely there may be instances where searching kind of employer property might be appropriate. But to the extent you want to or feel like you need to go through an employee's personal belongings, that's something you should refrain from doing. And to the extent that you think it is necessary, again, probably should consult with an attorney in that instance. So if the complaint is substantiated, so if the complaint is supported by the investigation, then you are obviously going to want to determine the discipline that you may, or the discipline that you're going to want to impose. And so think about the discipline that has been imposed in similar instances, right? So depending on the type of allegations that were raised and what was discovered through your investigation, look through your investigation files of similar instances and determine if the punishment kind of fit the crime, so to speak. So determine if whatever discipline was imposed in the past was effective. If it was effective, then there should not be really any reason to kind of deviate from the prior discipline that was imposed. However, if the discipline was not effective in past circumstances, then you'd want to kind of get together with the team that you're conducting the investigation with and think about, good reasons why it may be appropriate to deviate from whatever discipline you have imposed in the past. Because to the extent, the employee who is disciplined tries to raise a complaint in the future and allege that, the discipline was not appropriate and that it violated, Title VII or some other, law or regulation, one thing that employers have to think about is, are they going to be able to show that they have consistently disciplined employees for similar or the same conduct? And so to the extent that you are imposing a different discipline than, say, the discipline imposed in past instances, then you'll just want to be able to effectively explain what made this instance different, right? Well, we tried this before and it didn't work, so we needed to, do something more severe or, try a different method. Those could be good reasons for why you did something different. I think what's important here is that you have a reason and it's not just kind of arbitrary and obviously and not in violation of any law or statute. A key is just to think about the fact that discipline should be designed to end the misconduct. So whatever that looks like, just kind of thinking about that and carrying that in the back of your mind when you're thinking about what type of discipline to impose. Think about the misconduct at issue and what it is going to take to eliminate it. Possible remedial actions, and these can be by themselves or in combination with one another, a verbal or written warning. Even sometimes with verbal warnings, there's ways to document them so that, depending on the company, may be an available option. Certainly counseling and or training may be appropriate depending on kind of, again, the conduct at issue. It may be something that can be corrected by simply, training the accused or conducting a, workplace-wide training or counseling sessions in order to kind of prevent the conduct from happening in the future. Transfer or reassignment. This could be appropriate, again, depending on if the complaint is supported, if there was, some concern about, the individuals involved, the accused and the victim in this circumstance, then transferring to a different department or maybe a reassignment of a particular role could also be a remedial action that's taken. And again, to Megan's point earlier, depending on, if the accused is the individual and there was support to find that the conduct they engaged in was inappropriate, then if moving the accused is an option, then that is certainly something that can be considered. If the person who raised the complaint has requested the transfer or the reassignment, then it may also be okay to transfer that individual if that's something that they're requesting as a result of the outcome of the investigation. Delaying or withholding of a promotion, raise, or bonus. This is another option that is available. Suspension is another great option to use, particularly in concerning FLSA issues. Whatever you do, just make sure that you are documenting the action and don't reassign without a request or written agreement, because you certainly don't want one of the individuals, whoever is being reassigned, to come back and say that that was not something that they agreed to, or was done arbitrarily or without any reason. So making sure that that's in writing is key.
And I'm just going to jump in here and just acknowledge that we are a couple minutes over. So we're going to hustle through the rest of it. If you need to hop off, we completely understand, and definitely thank you for attending. And we will cut it a little bit short, but I think we have, want to get through the rest of if the complaint is substantiated and then what happens if it's not.
Yep, absolutely. So yeah, if the complaint is not substantiated, it still may be appropriate to recommend counseling or training. You might have discovered during the investigation that there are workplace issues that need to be addressed. And so, addressing those could certainly still be appropriate. Disciplinary action against the complainant should be considered only if there's clear evidence of a false complaint. So that goes back to the bad faith complaints that Meghan mentioned earlier. So potential discipline against the complainant if there's a discovery that the complaint was brought in bad faith. Preparing a report. So this is something that should be considered to be done after the completion of the investigation, again, so that the employer has it for their records. To the extent that there will be credibility assessments outlined in the report. These are kind of the list of things that the credibility assessment should be based on. The inherent plausibility, the demeanor, motive to falsify, corroboration, and past history. You certainly don't want to allow your own kind of biases or judgment to creep into those credibility assessments. Make sure you document the investigation and conclusion. So making sure you outline what the plan of action is, the investigation process, making sure you kind of have a place where you're keeping all the witness statements, and noting any significant developments that occurred during the investigation. And then, of course, the conclusion and recommendation, whatever that might be at the conclusion. And then the report should be done kind of as carefully as possible. So the investigation is very likely to be discoverable, and this is something Meghan touched on earlier. So make sure that whatever language you're using in there is not something that you would feel uncomfortable with, a judge or somebody else reading down the line, right? And so making sure that you just kind of follow the rules that we've kind of outlined thus far in the report as well. Best practices, we've kind of touched along these. And so never refer to a physical trait or other protected status. So that's something that you don't want to put in the report. There are some examples there because that is the type of language that could come back and haunt you if and when the report is viewed and seen by others.
And so these last two slides, they'll be in the presentation. I'm gonna just cut it short for the sake of time, I know everyone has probably a hard stop, and we are over our time, but if you have any questions about the last two slides, that talk about thinking, considering whether you change policies, et cetera, please don't hesitate to reach out to either Andrea or myself. We're happy to answer any questions that you might have, and we really thank you for participating today and listening in. And we will look up, I know there was a question about SHRM credit, so I will look into that. And if you want to put in the Q&A, if you're also interested in a follow-up, just go ahead and let me know. And otherwise, I think that's it. Thank you again.
Thank you.